This is called Dialogue, widening your horizons.
Hi, this is Arlene. We are back with more discussion today at our ABC Dialogue.
Hi, this is Gowri, and together with us we have a special guest today in the studio.
Every day we have a special guest, but today is much more special because we have Dr. Denison Jayasooria, Secretary General of PROHAM. Welcome to the studio.
Good morning to both of you.
And today we are going back to the Sedition Act, which we looked into very deeply last week. We had two different people to give their opinions on the matter. And of course, today we have Dr. Denison to give us another perspective on this Sedition Act.
In the last week, we had Sharizan Johan from the. He's a lawyer, so
Yes,
he gave
I know
a
him.
more the law perspective, and we also have someone from the government to share his perspective as well. And you, coming from an academic background, what do you see in this current Sedition Act being used quite frequently since last week?
Well, I think the provisions of a Sedition Act, 1948, is there in the statute books, and there is a constitutional provision for enacting such a law that protects certain rights and certain issues that cannot be questioned. So there is a constitutional provision to limit freedom of speech in that sense, and opinion and so forth. And so governments of the day have used this from time to time, and at this point in time there seems to be a crackdown on this, and it seemed quite intensive over a short period of time. And I think the real issue is it's coming post a promise from the federal government that the Sedition Act will be repealed, very much like the ISA and other legislative reforms, enabling Malaysia to be more human rights friendly, consistent to the promises made by the government during the election and post-election time.
And the promise has been made twice, actually, but they still haven't gone through with it.
Yes. I think, to be fair to the government, from what we read in the papers and what various ministers have been highlighting, it's undergoing a review process, and that there is some promise that it will definitely be tabled. But there seems to be some conflicting information from Putrajaya, because some say it won't be, some say yes, it will be repealed, others say it will be amended in some ways. So we might have to wait and see. But within that process, to aggressively use the Sedition Act that's been promised to be repealed then raises some credibility issues in the context in the political arena.
You're part of the Society for the Promotion of Human Rights,
Yes.
Short for PROHAM. What is PROHAM stand on this?
Now, PROHAM is a society that was set up by former human rights commissioners and former police commission members, and we have been taking quite strong stands in public over various issues that affect human rights, especially in the context of getting society and the government to affirm fundamental liberties consistent to the Universal Declaration. I think PROHAM's position is that the Sedition Act, which was first introduced by the colonial administration in 1948, is actually outdated. In many ways, even the language used is colonial English, because the word subjects are still used.
But it was being revised in 1969.
Yes. In 1969, when it was amended, some parts of the language was not changed. The provisions in which still remain, adding on the provisions not to question certain aspects like 153, 152.
But you added a few more provisions.
Yeah, and that comes into being. So PROHAM's position is that this stifles freedom of speech and that it should be repealed. And in its place, what should emerge is a much stronger opportunity for people, not so much to tear down these fundamental provisions of the federal constitution, but to have an open discussion on many of these things. And we also went on in a press statement that was issued recently, calling on the federal government to amend the Mediation Act of 2012 to make it mandatory for people to go through a mediation and conflict resolution. Because one is people are making statements based on their understanding of history or their interpretation of the federal constitution. There are very few people who have stood up now, including the far right wing, or if you want to brand some people on extreme liberal or whatever, all are affirming the federal constitution. But the question is their interpretation. So it's now getting people to sit down in some compulsion to talk about this, because PROHAM does feel by someone just stating it, it doesn't mean you can wipe away these provisions that are protected by the federal constitution. You need 2/3 majority. You need the agreement of the Council of Rulers before any one of these provisions can be removed. So I think some healthy discussion of some of these aspects might be necessary.
Yeah, interesting that you brought in the Mediation Act 2012, because I think not many people know about this particular act. Perhaps you can share more about this act, and have the government actually utilized it for any purposes?
You see, the Mediation Act, which is slightly different from the Arbitration Act and all, is to provide an avenue of non-criminalizing an issue, where people who want to sue one another, now it's more at a voluntary level, could actually, instead of going through the court process, sit through a mediator. The mediator is not a judge. The mediator mediates between the people to come to some conflict resolution. That resolution could be brought to a court. So I think one provision would be, many of the statements people are being charged for, unless it has violence instilled into it. That means you want to violently overthrow the government, or you want to dismantle the monarchy and things of this sort, where violence or incitement of hate to acts of violence. I think then there should be provisions, and there are some provisions in the penal code for that. That needs to be strengthened. But open discussion on some of the things might be helpful. It's not questioning let's say, even if you take the Perak issue
Crisis,
of the assembly, or the Selangor issue. I think you need to look at the various possibilities and provisions. Now, some academics have written about this well. Professor Shad Faruqi is one. You have other academics who write in an academic way. But there is very little discourse in the media or even discussions where you can look at position A, position B, position C, and what should be the position. So there is what one would call not a climate of fear, but an argumentative climate. Not
more like
of
Socrates and Plato during
Yes,
that time.
I think to sit down and talk, because I believe on the whole Malaysians are reasonable people. You can put them around the table. Now the problem is many people are talking in press conferences. They are not willing to come into the same room. You need to put the people into the same room where they then say position A or position B. Because I've even heard the far, what one might call right-wing, racist, or whichever people are accusing everyone of racist. They all are affirming Rukun Negara. They're affirming the federal constitution. They're affirming a sense of fear of God and of religion. Then we are reasonable people. But when we are not sitting together, we sound very unreasonable in the way.
Yeah, especially in the media. And to state that the Sedition Act has been used not just to charge the famous one would be the infamous one would be Azmi Sharam, but also ISMA leaders and journalists and all. It seems like people are seeing the Sedition Act as the new ISA since the ISA has been repealed. What do you think about this?
Now, I think the climate of fear under the ISA is quite different under the Sedition Act. There are some similarities, but there are major differences. Under the Internal Security Act, you can be arrested and kept in comunicado for 60 days. Then you can be detained without trial. I think that is a draconian form which cannot. I know some parties are wanting it back. I think the global human rights scene and national scene, you cannot reinvent preventive detention in the way it was there before. Now, the Sedition Act, in one sense, brings the person to open court. But I think the drawbacks is the way the Sedition Act has been written and how it is in the legislation, that it will convict if somebody is charged under that. The courts, I think, in my opinion, might not have the law in itself is very restrictive. I think in two ways, because if someone said the intention of what he said, let's say he was giving a legal advice, or he's a professor explaining the scenarios, then they could be charged because he is now saying something on the issue. So if you make a comment on the judgment in Parag or the royalties involvement or some of the issues, then you can be charged because the Sedition
Even with
Act,
or without intention.
Yes, the intention is not
considered.
So if your intention was just a legal advice, but if they want to charge you, because some politicians have said, look, there is nothing restricting rational, objective discussion. And some get away with it, but it will instill, I think, a sense of caution. Because I read what Professor Azmi said on the Para case and how he referred it. I didn't see anything controversial in it.
It was reported by the Malay Mail online.
Yes.
And
so if you take that, but from lawyers that I spoke to, it is very, based on the law, it is a seditious statement, So then people will become more cautious. And if there's large numbers of people being detained under it, and some people not, because I would feel, and this might sound controversial, and I stand corrected, the recent Tun Hamid's statement that non-Malays didn't fight for the independence of this country could be seen as seditious because he's creating an upset in the way history was projected and provided. And then he goes on to say that the land should be returned to the Malays, which then is contravening provisions of citizenship rights and equality rights to ownership. That doesn't question Article 153, because 153 affirms the special position of the Malays and natives of Sabah and Sarawak, but also the legitimate interest of other communities. So the balancing document will emerge. But what it does is, it does instill a caution on people, and possibly that's one of the intentions. But I think I would say the current legislation that has, you cannot speak against any government.
Even state government, as in like,
even state,
regardless whether it's opposition
state
or Barisan
federal,
Nation,
to point out errors or defects in any government. I re-looked at the federal constitutional provisions of this, and the federal constitution in Article 10, 2A and 4A only permits Parliament to pass laws prohibiting the questioning of any matters, rights, status, position, privileges, sovereignty and prerogative established or protected by provisions. Part 3, which is the citizenship, which I think Tun might have contravened Article 152, 153, 181, which most of us affirm. But it doesn't bring any criticism on the federal government or state governments, which then is a provision in the Sedition Act. So I think people don't want to go through a process of being picked up, being questioned, being interrogated, maybe even kept overnight. And that's a kind of a traumatic experience.
The Sedition Act is under the purview of the Attorney General.
Yes.
And why the cabinet or the federal the Najib's administration has been quiet about this since Azmi Sharum's case?
I think from what I read in the media, the Prime Minister's office has issued a statement saying that it is looking at the review of the one, and it has indicated it's in the hands of the courts and the Attorney General if they want to charge. So the current act provides the law for the police to investigate, and I don't think that's wrong. They have the right to investigate, and it's definitely in the hands of the federal government if somebody is to be prosecuted and to what extent and what kind of a signal they are sending. And I think the impression is it's a kind of a crackdown. I think it's different from the ISA, but it's a kind of a crackdown, and it will have some impact on freedom to speak. But it might add the cautionary note of how you want to. But I think most people feel that it's still a bit selective, and it seems to be much stronger on one side. And so if the government is transparent, open, and act across board, and then open media forums and discussion groups that is more objective and rational discussion, then I think you will see the scaling down of extreme statements of either side. I think the problem is you don't have a safe environment to discuss, because in many cases it's political pronouncements. There's nothing wrong for a young person to actually have a doubt, why this or not, and what are the various positions. And so whether it is political science or the academia or civil society, there should be opportunity to discuss it, but in a way not trying to demean it or in a way to cause the kind of reaction. But I think people need to, and I believe Malaysian society is a rational society, but we need to give the full information. I believe half-truths are being given, or people don't get an opportunity to hear all sides of the story. Because why hold a colonial piece of legislation that was there to stifle independence?
It was for a very specific purpose. Even the revision of the act itself was because of the racial riot that happened in 1969.
Yes. I think historically it is important, and even now it is important for us to hold in balance. I think some of those provisions should not be questioned in the way some are questioning it. But I think clearer explanations need to be given. In some cases where questions of those provisions are being asked, it's because of the abuses in implementation. And so federal government must be far more cautious in its implementation of 153 or 121 and other provisions, even of religious freedom. Then people will raise it. And what I'm saying is, even if a young person raises it in a disrespectful way, I think we must give a leeway first before we criminalize it. That we must give an opportunity for some discussion and negotiation and sort of counseling. I'm not saying terrorize the person into accepting it, but I think through a reasonable process, because the person might not have the full information, in a safe environment to have a discussion. Maybe if it's a young person, with the family members or with other senior members of their community. If it is others, then I think let's sit down and talk. Why this person feels such, and if a law professor makes such a statement, then I think the current sedition laws should be amended to take away the colonial language one. It should be best reflected in the federal constitutional provisions of Article 10, 4, subpoint 4. It should also bring in that if what is being said is actually truthful, then you can't charge the person.
But if you have the penal code and the constitution, why the Sedition Act should be revised instead of being repealed?
Okay, I think the penal code, if one sees it now, has the provision of offences against religion, and that comes out in section 10. It has the section which is criminal intimidation, intentional insult, and things like that. The penal code doesn't seem to have a strong provision for racial discrimination. Contempt of court proceedings are already there related to judiciary. So the penal code could be strengthened to make such issues, What I'm trying to point out is not in all circumstances, what a person or a young person or even an adult utters should be criminalized so fast. Because the criminalization of it in the Sedition Act is imprisonment and fine. And imprisonment up to 3 years and fine up to 5,000. And I think that might be too drastic in the current climate post 2008, 2013.
It's a different kind of situation.
I think the society has changed, the global environment has changed. Malaysia should go after those who are more militarily training.
Sounds like you're mentioning ISIS here.
And things of that sort.
We will continue our discussion, Dr. Denison, and
Sure.
more discussion on what's the way forward.
ASEAN Breakfast Call Dialogue, widening your horizons.
Hey, we are back again. This is Arlene,
This is Gowri.
and with us is Dr. Denison. Jayasooria, how are
Yes,
you?
I'm okay. I'm still here.
Just now off air, we have a very interesting discussion. First of all, I want to ask about the Sedition Act. Earlier, you mentioned that it was actually mentioned in the federal constitution.
Yeah, I think I have been informed that there are 2 references to the Sedition Act in the federal constitution, and if it might be necessary to amend those provisions in the federal constitution, and that the federal government might not want to risk going through that process. But that is something for more legal experts to look at. The references are in Article 63, Clause 4, and Article 72, Clause 4, where there's a specific reference to the Sedition Act. But the government's promise of repealing it, largely the Prime Minister's promise, and to then institute the Harmony Bill, from what I gather, it is still in the process of interagency discussion. The National Unity Consultative Council's Working Committee on Law and Policy Reform made a draft, and there's a lot of confusion over this process. But it's only a draft, it's a recommendation, it's a suggestion.
I think that's the problem a lot of civil society are questioning. Like, they are expecting for the Prime Minister to uphold his promise of repealing the law and replace it with the National Harmony Act, and it seems like it is stuck somewhere where people are not sure whether it is moving forward to become a real act or not.
Okay, in normal circumstances, any committee intends to do principles and pointers towards drafting a legislation. In the NUCC Law and Policy Reform Committee, because there was the presence of a number of lawyers and they got the support of lawyers in the working committee, they then drafted something. But that is not a government document. It still has to go through the formal process of the Attorney General's office. And we have heard this from the Law Minister as well as the Attorney General, that they are reviewing that proposal and also getting feedback. So the NUCC process was a feedback process, and we have done, some draft and some pointers. But that's from a working committee level. It's not the main NUCC on it. So this is where a lot of people jumped into conclusions. But nonetheless, I think government will have to review it and to look at the current weaknesses. But I think holding some balance to the constitutional provisions of protection on non-questioning of the monarchy, issues related to religion and religious freedom, issues related to Article 153, these are intact. These are not just protections for one set of the community. Often it seems
You're
to
mentioning,
be...
you're referring to the National Harmony Act.
No, I'm referring to the constitutional provisions for protection of some issues, like Article 153, Article 152, religious freedom, monarchy. It's not just the protection for the Malay community or the Bumiputras, it's also the protection of minorities. And this they are forgetting, because in the federal constitution, every act is a balanced one. If it is the position of Islam, then there is the freedom of other religions. If it is a national language, then other languages can also be taught and studied. If it is special measures for the Bumiputra and natives, then there is the legitimate interest. And so campaigners on the ground are forgetting this balance, a healthy balance, sometimes even contradictory balance that the federal constitution provides. So you can't say, and AG is right because he has charged, you can't tell a non-Malay, you're a pendatang, get out of this country. You can't say that because it's protected under the same sedition laws. And so I think maybe there might be a need for a special cause on Sedition Act. Maybe civil society should have it. But the way, as I said before, the current law is worded, where intention, you cannot plead on your intention, or you cannot plead that what you said is the truth, which is the protection in all other criminal proceedings. So any amendment to this, and this is what the Harmony Act of the NUCC Law and Policy Reform Committee, they have brought the element of intention into it. There is still the strong protection on incitement against rulers, incitement against racial hatred.
There are three different acts that was proposed under
Yes.
the National Harmony Act.
Yes.
Can you mention all of it, all three?
This is from the Law and Policy Working Committee. They felt that you cannot put everything into one act. So the first act or the bill they are proposing is legislation on racial and religious hate crimes. And that is the replacement of the Sedition Act. And the argument used by some of the lawyers who helped draft it is saying that the penal code does not have any provisions against racial issues. It has on religious issues. The second bill that they are proposing, which is on national harmony and reconciliation, is more the overarching legislation in which the consultative council will operate, which is then the final one, which is the commission. So instead of a council that is not independent, doesn't have the status like Suhakam and things of that sort, The third bill is proposing a commission. So there seems to be some confusion. Why 3 from 1 to 3? You're over legislating things and all that. But the provision is moving beyond the Sedition Act. And in both the commission, the bill that will set up the commission, and the bill that will legislate national harmony, this provision of mediation comes in. There is a provision of a tribunal as well. So groups that oppose this are basically saying you will open the floodgates to question many of the protection which 153 or 152 provides.
When you say mediation, would it be public or would it be in an area that is like safe space for everyone?
No, I think a mediation would then mean if somebody commits the offense, they are mandated by law to go into mediation. And that is a first process before it's criminalized. So,
and what's wrong with mediation according to the view of this
I think
group?
people feel that some issues are no-go for public discussion. And that's a valid position. Because some people want the ISA back because they feel it's safer. They want control of media. They want control of discussion. But it's no longer possible in the age of Facebook, in the age of all kinds of things that is open for discussion, and in the global sense that there has to be open, transparent discussion without being, I think we are still struggling with an Asian culture. You know, as older people, you don't want a young person to stand up and question your integrity. I think the world is such that by questioning any one of these provisions, you cannot remove them. I think there's a kind of insecurity in the hearts of many people who are objecting it.
And for these people who are objecting this, why they have this sort of mindset? What is the insecurities that they have in themselves that causes them to oppose such such open discussion on issues that are very sensitive?
I think they would feel strongly that the federal constitution has a certain set of understanding and agreement, which is historically there. We have to go back to 1946, 1948, 1957, and the historical developments to 1963 with the formation of Malaysia. Some people are still caught in the 1946 arguments. They have not come into the current period of 57 years of independence. Now, having said that, you cannot wipe away history. You cannot wipe away the fact that this is a Malay land in which there is the provision as a result of the federal constitution and the independence agreement that Indians and Chinese and other communities that are citizens have equality before the law. But we still have to take the historical fact of the Malay language, the Malay royalty, and things of that sort. I myself am a federal Datuk. I go regularly to the palace whenever I'm invited, and I count it a great honor because when my grandfather first came, he never had a chance. My father, who's locally born, has a much smaller title from the king. But we are loyal subjects or citizens of the land. You cannot rub away or wipe away that history and the legacy. And that's the richness. At the same time, the new reality of Malaysia is that you have kids now who might be Indian or Chinese, who don't look Indian or don't look Chinese. They might not even be able to speak their own mother tongue, but they might be fluent in Malay. Their English is as bad as other kids. So for this generation that's fifth or sixth generation or seventh, they have very little affinity to India or China or any other part of the world. And they then struggle with being branded in a way that you are non-Malay, you are non-Bumiputra.
In the
and
process
things like
of mediation, as the paper that you mentioned just now, what is a no-go topic? Like, can the subject discuss almost any topic, or if they come into like conflict on any issue, or is there
I
like a
think it
no-go
will be
topic?
any issue related to religion or one of the violations under the provisions, which
Like, can they question Sharia law, whatever institution that we have?
I think if they were objecting or raising issues vis-a-vis that, they could discuss it. But those are certain things that are historically taken, and they are not subject for change or review. But I think the issues related to Article 121(1)(a) vis-a-vis a non-Muslim spouse with a Muslim spouse or a new convert is something that hasn't been resolved. By discussing that, it doesn't mean you are disrespectful to Islam or religious freedom. I think we need to distinguish that. But there are certain issues vis-a-vis 121(a) which a non-Muslim spouse would face before a Sharia court. And there have been various recommendations vis-a-vis that. And I think this is where government at any level must act with some sense of expediency to resolve or reset institutional arrangements that are in a conflict situation. That means there is a grievance. You need to find some resolution to the grievance. If it continues on and on, then it will burst, of some kind.
Especially in this era where you have you get a lot of your information from Facebook and other social media platform. Some of it can be quite extreme, the messaging.
Yeah.
And nowadays you have more online news than ever before.
Yeah.
Like in the 90s, there's only like Malaysia Kini. Now you have like, a dozen of it. And all of them have their own way of reporting and getting information. How can such influx of information, some of them can be seditious, some of them can be extreme, how all this can fit into the framework where you want to maintain peace and order within society, and you don't want them to sort of like go over the framework that has made Malaysia.
I think the problem why people go to alternative media is the credibility of mainstream media. So I think if mainstream media has a proper balance of information and not propaganda, I say very often mainstream media might be propaganderist in its approach. But if there is an openness and if there is objective reporting of issues, I think people will return to where they believe you can see then, let's say on TV, you can see a member of the opposition, a member of the government, an academic, a civil society person discussing the issue. Then I think people will sit and listen. Now they can't hear that. So they're either going to camp A and then getting one side of the information. So if you are watching mainstream media, you're only getting A. If you're watching B or C, or your sources of information is in the very informal, you can try and control it, but it's very tough in the current process. So what's the way? I think the way is open, rational, objective discussions that people will know that this source of analysis is accurate, but they will allow for alternative views. But what is happening now is if there is a stifling of alternative message, or criminalizing the alternative message, or victimizing the alternative message, then people will flock to the alternative voice.
And
it's just human reaction.
It's just human reaction.
Yeah, and so in any objective, innovative society, you must have open, rational discussion.
Especially in terms of the media, the mainstream media platform.
Yeah. I think where we should be restrictive is if it is violence, if it's recruiting people, if it is building hate, anger, vengefulness, that can be monitored. And you can see websites or training avenues or talks of that kind. But where people are legitimately questioning something, providing a synthesis and an alternative view, I think that should be encouraged. That's the only way to prevent extremism in society.
So, Dr. Denison, we have reached the end of our show. But before we wrap up, what's your message in conjunction with Malaysia Day? What's your ideal Malaysia?
I think Malaysia is, I've traveled, I've lived in India when I did my undergraduate studies and lived in England doing my postgraduate work. I feel Malaysia is nothing like any other country. And this is a great place because of its rich diversity, richness of culture. I have very good relationships with my Malay friends, Chinese friends, Indian friends. Maybe I need more Sabahans and Sarawakians, but definitely with the Orang Asli community in the work that I'm doing. I think it's a great land. I think we should not allow individuals to tear us apart, but we should build the nation through moderation. And we should elect leaders who can stand up to this. And I think the real crisis is academics are not speaking up. I think they must. And of course, some will get victimized in the process. But Malaysia is a great land, and we need to build it. And we need to work around our difficulties. So don't X people out, don't throw them out into the sea, but try and see how we can be more inclusive and accommodative of all the different variations of society. And I think in that way, Malaysia will stand tall, especially in the midst of the rise of Asia, rise of India and China.
And Southeast Asia.
And Southeast Asia and ASEAN. And Malaysia can play that role. And if next year Malaysia is the chair of ASEAN, we cannot be squabbling among ourselves like this. We should stand tall as one people after 57 years or so many years of Malaysia Day. We must stand tall as Malaysians. All of us, whether we are Malay, Chinese, Indian, Sabahan, Sarawakian, Orang Asli, we are Malaysia together.
With that, thank you very much, Dr. Denison.
Thank you.